Yes. $27. Okay. Heard Mr. Is Abdullah P. the learned counsel appearing for the accused applicants. He submits that he has instructions to withdraw the listed AD application. Prayer is allowed. Matter is dismissed as withdrawn. Next case, Kanengo, the learned counsel appearing for the applicant, submits that this matter has been wrongly listed in the order column. Rather, it should have been listed for admission. Let the matter be listed for admission column. On 24th March. 22. Yes. Okay, CD, Mr. A. Martin, A.M. Ahmed is present. CD not received. Let the matter be listed on 23rd. 23rd. For Monday. Hmm. 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 Yeah, let the matter come, let the matter come. Let the matter come. 14. Yes. Withdraw. You, Mr. Huh? Learned counsel, Mr. P. Bora, submits that he has instruction to withdraw this case. We withdraw the matter. The matter is dismissed as withdrawn. Yeah? Item number 10. Yes. On the prayer of the learned counsel appearing for respondent number 1, which respondent number 1, let the matter be let the matter be listed on 26th. 26th we are giving. 26 March. 29 you write CD not received. Let the matter be listed on 24th. Interim orders of past earlier shall continue till the next date of listing. Item number 34, CD not received. Let the matter be listed on 25th. Yes. On the prayer of Mr. A.R. Karim, which was not objected by the other side, let the with the consent of the other side, let the matter be listed on 26th. 26th. Item 45. CD not received. Let the matter be listed. Hmm? Okay, then we'll just adjourn it. Maybe like they'll file it. Okay, okay. Under prayer of the learned counsel, preparing for the accused applicant, let the matter is adjourned for the day. The same will be listed on 24th March. Why you have filed affidavit? What notification? It's a bail application. What notification? Okay.
No, 48 for withdrawal.
You draw. You are. Her MSN and Chakraborty, she submits that she has instruction to withdraw the instant application. The matter is dismissed as withdrawn.
Option B, I think number 1.
Why you have come? Hmm. 7 months? Hmm. Oh, earlier rejected. Yes. Yes, now why you have come? Hmm. Hmm. We'll call for the TCR. I mean, heard Mr. A. Karim, the learned counsel, and Mr. K. Parasar. These are application under so and so. Then you write the matter relates to. Matter relates to recovery of P1 spas capsules and other contraband materials. Right. Raised you to call for the TCR. In the instant case, let the matter be fixed on 24th March. 24th March.
Item 2.
Yes. How many days? Where is the affair? Okay, we'll call for the CD. That has to be looked into. Or Mr. A. Karim and Mr. K. A. Parsa. This is an application under so and so. The case relates to filing of an FIR by the informant releasing attempted rape on her by the accused applicant. Full stop. Call for the CD. Let the matter be fixed on 11 to office. 11.
Item 3.
We'll verify that. We'll give a short date. Then we'll see. Let the CD come. But it seems there is no signature. 36 violation. Mr. Pora, sir, I don't think anything else will come. You right, heard Mr. S. Islam. S. Islam, the learned counsel appearing for the accused applicant. Also heard Mr. K. K. Parasol and APP for the state. This is an application you write. Then you write an FIR was lost on 23/11/2025 by one. As you can write from here, huh? Page 18. Page 18, you take para 3, okay? Then you write para 4. Then you write the learned counsel submits that earlier bail application in the same case as already was rejected by this court on 16/2/2026. However, he has filed this instant application with a new ground. Then you write that is non-compliance with the mandatory provisions of section 36 of BNSS. Full stop. Then you write 5, 6 from here, huh? 5 and 6 from here. Then you write the learned APP. On the other hand, submits that case the evidence in case is required. To stop the further submits that that the instant case involves recovery of the commercial quantity, commercial quantity of narcotics contraband. What was it? $20 bottles of 20 bottles of you write 20 bottles of so and so from the possession of the accused applicant. Therefore, the rigors of section 37 of NDPS Act shall be applicable in the instant case. He further submits that only because a procedural lapse has occurred while arresting the accused applicant by not attesting arrest memo, by attesting the arrest memo by one witness shall not give any right to the accused applicant to be enlarged and bail. Full stop. Then you take it from here. Then 5-6 पहले then submissions जो दिखा अभी ना उसके बाद 8 then यहाँ पर 8 लोगे 9 10 11 12 13 14 15 16 then 18. Okay, I marked it here. You take it from here. This inside this. Take it from here. Okay. Oh, you write special just outside now because satisfaction of the special just outside now. But there will be some stringent conditions. Will be allowed. Hmm? Hmm. Hmm. $34. Main accused have been granted bail. Okay, we'll take it up at 34. We'll take it up. 34. You intimate the DRI council. He is also arrested in the same date, same place. And it was given to Gavra, 48 notice. Given to whom? 48 was given to his wife. Hmm. No, that 47, I mean, the same case. Mr. Podarongia case. All accused have been already granted. You write heard MSL Bonic, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Bora, learned APP for the state. Okay. Then number 2 from you take it from here. Number 2, number 3, number 4. You produce on the same day. 5, you take. Then 6, you write instead MS L Bonic, huh? L Bonic, learned counsel appearing for. Para 6, take it from here. खाली नेम चेंज करने का. Then यहाँ पे भी 7 पे भी नाम चेंज करना. और यहाँ पे खाली C होगा पैरा 7 पे. यहाँ पे लिखा हुआ ही फर्दर सबमिट नोटिस सेक्शन 14 गिवन टू वासिफ से क्या नहीं. यहाँ पे लिखना whom it was given to whom? Nazima Begum, wife of the accused applicant. However, the same was not served in the language understood by the accused applicant. So, therefore, she submits that the same being violation of the ratio laid down by the Honorable Supreme Court. मार्कर है यहाँ से नहीं लिखने का, ऊपर का पोर्शन ले लेना, बाकी नीचे का नहीं लेना. दैट सबमिशन डालना. देन पहला 8 डालना. 8, 9, 10, 11, 12, 13, 14, 15, 16. Okay. One applicant, ना? और यहाँ पे accused applicant करना, applicants नहीं. Single person. उसको बना लेना, इसको यहाँ पे यहाँ से लेकर. ठीक है. नहीं समझेगा तो मुझे पूछ लेना. Okay, we'll allow this. No, your submission, I mean, already, I mean, you have stated, I mean, earlier cases also, the submission was basically the large quantity was received, I mean, recovered. Then on the spot, it was recovered. And the submissions are there. And you are opposing it. The same case, no? All the cases are on the same footing, totally same footing. All the people are recovered. I mean, Mr. Parasar was there in the other cases.
I think 5.
That Rongia matter, you were Rongia case. Same footing. I mean, no signature was taken. No signature was taken from the of the arrested person. So that means total non-compliance of section 47. Yes.
5.
Yes. Hmm. 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 Last order, please. 28. Yes, what is that? Yes, charges have been framed. The charges framed, then But why do you need the trial court record? Charge sheet is already there, na? You've given. Okay. Heard Mr. P. Das, P. K. Das, Learned Counsel, paying for the so-and-so, Mr. Arjay Burwa, Learned APP for the state. This is an application on the so-and-so. The case relates to causing grievous injury on the daughter of the informant. The registry to call for the TC scan copy of the TCR. Let the matter be fixed on 24th March. Now all booked, all full. The scan it's all full. I mean, I'm saying the dates are not there. I mean, very difficult. Earlier, all dates are full. That's why I'm saying.
6.
I will call for the or Mr. A. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. So and so. Is an application under so and so. Call for the case diary. Let the matter be fixed on 23rd. And in between, you write the matter relates to recovery of. What is the quantity? Recovery of 1.0. Huh? Grams of ganja, no? Sorry, brown sugar, yes. Brown sugar. That's the matter. Okay, then you write registry to call for the trial court records from the court of special judge and DPS Sribhumi. On 25th.
I think
Let
7.
them fix on 25th. Bill was rejected earlier. What? Yeah, Mr. Borua? Where is the FIR? I mean, And on the basis of this FIR, you have been arrested. Yeah, when you were arrested? It's a Borwa. Let him go. क्या करेगा? I've seen that already there. He has been already released in another case. Another case he is already released. Yeah, page 11, where? What? Yeah, breaking of certain things. Yes, I've seen. Hmm. Let him go. Heard Mr. S.M. Abdullah P. the learned counsel appearing for the accused applicant. Also heard Mr. Borwa, learned APP. This is an application under so and so. An FIR was lodged on 8/12 on 5/12/2025. Is it 5/12? 5/12/2025 by by the chief manager of SBI Kokrajhar branch, alleging that some miscreants has broken the CCTV camera and the door of the ATM booth located at Pathorghat in bracket near Kali Mandir, Kokrajhar, Kokrajhar. On receipt of the FIR, police registered the Kokrajhar PS case number 273/2025 under section 305/3324 in bracket 4/331 bracket 4 BNS, read with section 3 in bracket 2 in bracket small e, Prevention of Damage to Public Property Act 1984, full stop. After the investigation, police arrested the accused applicant, and he was forwarded after his forward to the CJM Kokrajhar. He has been sent to jail, and since last 10 days he is inside the bars, full stop. The learned counsel, if any for the accused applicant, submits that the incident you're right. He submits that the accused applicant is the learned counsel submits that the accused applicant is no way connected in the alleged offense. In fact, he was earlier arrested on suspicion of a similar case of vandalism, wherein he has already been granted bail by a coordinate bench of this court, by order dated 5/2/2026. 5/0/2025. 5/2/2026. Full stop. After he submits that immediately after subsequently after he is released from jail, that wasn't okay. He was released from jail. He was again arrested on 18/2/2026 in connection with the incident case. He submits that this case. But I mean, vandalism happened on. Correct, December, so December there was nothing. Hmm? Anyways, he submits that since the accused applicant has been arrested only on the basis of suspicion as he was involved in the earlier case, this court should grant him bail. The learned APP, on the other hand, opposes the bail application, saying the case that it should be called for in the instant case. Also, after perusal of after hearing the parties, after hearing the counsel appearing for the parties, as well as perusal of the materials brought before this court is of the considered opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith on furnishing of a bail bond of rupees 20,000 with a severity of like nature, the satisfaction of whom learned CJM Kukarajha, subject to the condition that the accused applicant shall appear before the investigating authority, as and when called for, and fully cooperate with the investigation. And another condition is put up, these two conditions, and another condition will be that he is not hampered or temporarily put it. Okay. In view of the aforesaid direction, the instant bail application is disposed of as allowed.
8.
Hmm? Hmm. Hmm? What is this? Case is about what? Okay, heard Mr. SK SN Mohammed, the learned counsel appearing to the accused applicant, also heard Mr. RJ Bora and APE for the state. Recent application under so and so. The new right the case relates to. How many of you are there? Only one person. One person. The allegation against the accused applicant is of waging war against the nation, as well as connection with several terrorist organizations. Full stop. Call for the CD. Let the matter be listed. When, Mr. Bora? 23rd March.
49 supplementary motion BA.
So we'll. So we'll call for the TCR. Heard MS so and so. Also RJ Burwala is an application under so and so. Then you write the gist of the allegation against the accused applicant. No, don't write gist. The case relates to. Just write case relates to. LA's commission of Alleged commission of sexual assault by the accused applicant. By the accused applicants on the daughter of the informant. Daughter of the informant, okay. Raised to call for the TCR in the instant case from which court? Learned special judge POCSO, Lakhimpur, not Lakhimpur, no comma, not Lakhimpur. Later matter will be listed on 24th March.
C, motion AB.
List? So we'll have to call for the CD in this case. So we will give you a short date, but we'll have to see the CD in this one. That's what. So I mean, allegations are serious. So we'll have to look into the CD. But the allegation is serious person has died and there is a suicide note. So we'll look into the CD, then we will consider it. Or okay, we will try to look. I mean, accommodate you. I mean, in early date, or Mr. R.P. Sharma, the learned APP for the learned counsel, senior counsel, assisted by M.S. M. Bora, the learned counsel, appearing for the petitioner, for the accused applicants. Accused applicant, you are only one person has come, right? Only one person has come. Okay. For accused applicant, also Mr. R.J. Borua, this is an application under so and so. The case relates to commission of suicide by one person, and suicide by the father of the informant due to alleged mental harassment by sending WhatsApp messages, by sending continuous WhatsApp messages in a WhatsApp group, full stop. Call for the CD. Let the matter be fixed on too many matters are there, but 6 not possible. Too many matters have already listed. Okay, 9th we'll try. 9th of March.
So motion item number 9.
But I am as the owner, I am not there with that. And also not the transaction. I am the owner, I am there.
But you were transporting with, I mean, you have any documents for transportation? So who were transporting? Huh? You hired the vehicle or you given for, you have given for rent, you were the owner. You are the owner, then you will, how you will hire your own vehicle? You give the, who were transporting? Okay, we'll see the CD, heard Mr. So-and-so. The learned counsel appearing for the accused applicant also heard Mr. So-and-so. There is an application on the so-and-so, you write, the case relates to recovery of cattle from the vehicle of the accused applicant, full stop. Call for the CD, let the matter be listed on 13th of March.
Item number 12.
Yes. Hmm. Okay, Mr. D. Das, the learned counsel appearing for the accused applicant, submits that he has been newly engaged and prays for some accommodation. Prays for some accommodation. PCR was not called for. Needs some accommodation, full stop. MS, your name? R. Hussein. MS R. Hussein, you are appearing for? Kyle. Appearing on behalf of Mr. Kyle, submits that TCR in the instant case is yet to be received. Full stop. Let the matter be listed on 9th of March. 9th of March. Registry to call for the TCR in the instant case. Registry to send a reminder for the TCR in the instant case. It will come from where? The entry notice of past transactions will continue till the next date of listing.
13.
Yes, what happened to this? Now you want to say those are for cosmetic purpose? Huh? The codeine phosphate is for cosmetic purpose. Huh? So you are bringing a new thing, very new thing. The codeine phosphate is a cosmetic. Hmm? Hmm. What does it say? What does it say? You read. Hmm. 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 What is the concentration in your bottles? What is the percentage of concentration? So that is a full thing is codeine only then. Mr. Counsel, in a codeine phosphate bottle, that Corex bottle or fentanyl bottle, what is the percentage of codeine there? It is written in the labels. What is the concentration? 0.2. What is he submitting?
That's in my notes. You could have verified the exact quantity of the bottle has been taken. That's not the industry doesn't.
No. What is the percentage of codeine in a cough syrup bottle? Please show me from where we are saying 0.2%. Yes.
Bottles, 100 found in the room of Yusuf Khan and found inside the bag. And 7 numbers of bottles of penicillin, and bad cough syrup, bad provision is according to the
So what is there? What is the case?
very much bad.
So cough syrup is not narcotics. The codeine phosphate is not narcotics. Ah. Nothing. You see, you have got the additional affidavit? See, don't submit in the, the cases which are not relevant. If there are relevant cases, you submit those cases. Those are welcome, but don't submit some irrelevant cases and waste the court's time, huh? You submit if those are relevant. You see what those are no which point? No, but which point you tell me? See, your seizure were 34 numbers of bottles of fancy grip anti-allergic anti-tussive dry cough that contains tripolidine, hydrochloride, and codeine phosphate syrup. So codeine and tripolidine are contraband materials. All batch number ALS25 manufactured on so and so. Each bottle contains 100 ml found in the room. Okay. And 17 bottles of same have been recovered from the other person. Correct? So tripolidine, hydrochloride, and codeine phosphate, those are narcotic brands. Those are narcotic substances under the NDPS Act. Now, what is your argument? I'm not understanding. You are saying that this is cosmetic, and how the cough syrup can be used as a cosmetic? I could not understand. Huh? Drugs and cosmetic understood. Now, if it is, you say cosmetic. Okay, it's not cosmetic. It's a drugs used for what? Hmm? What medicine purpose? This is a cough syrup. So cough syrup, it contains those narcotic, narcotic substances, and those are you are not supposed to sell it without any prescription. it is not on the counter, off the counter drugs, and you are keeping those materials, I mean, in your place without any document, then are you not supposed to be liable for this? You have any other arguments, you please tell. And where are the cases you have given? What cases you have given? Judgment on what? Which point? No, no, which point? No, what is your point of argument? You give me the case like this. Yes, where? Which page? Hmm? Iqbal Singh, yes. Hmm. Page number 3. Hmm. One second, one second. Methyl morphine, yes, methyl morphine. Um, where is that? I mean, how much percentage is there? Is there any measurement? Is there any this thing? I mean, is there any report on that or any kind of measurement? Judgment I'm not talking about. I'm talking about in your case. In that case, there was a statement made that if codeine phosphate is more than 10 grams, then it is narcotics. So in your thing, I mean, total how much is there in? I mean, see, mixer is 0. In this case, the mixer is 0.17% per milligram. So it was calculated to 100 milligram. So if 100 milligram goes beyond 10, then it becomes narcotics. So here in your case, like what is your submission? Then how are you submitting that it is lesser? Now that is the problem. Now how the court is, I mean, how then if you have the problem, then you should sort it out. Now, I mean, without measuring it, without doing this, how can you make a submission that it is lesser than 10 milligram?
Other ingredients, protein phosphate, you can't
It says if the percentage goes in 10 ml, if that codeine content is more than 10 gram, 10%, then it becomes a narcotics. So you'll have to show from documents that it is below 10 in each of the bottles. Do you have any document on the, I mean, on that, any material on that? Hmm? Hmm. Correct, correct. Okay, I'll give him one date. Let him bring. Heard Mr. So and so. And also Mr. So and so, the pair of the learned counsel, later material fixed on 26 March. 26 March. 26 March, not be before that. Lot of matters have been fixed. Note, it will not be, I mean, it won't be listed.
Item 15.
Service report on a respondent number, service report of service of notice on respondent number 2 is awaited. Let the matter be fixed on 26 March.
Number 16.
Hmm? Service, same order, same order. Let the matter be fixed on. Charge sheet submitted. Charge sheet submitted, you go and appear. Heard Mr. M. Mondal, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borua, learned APP for the state. This is an application you write. Then you write, the case relates to registration of an filing of an FIR alleging alleging attempted sexual assault on the daughter of the informant. Full stop. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number so and so. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he would like to approach the trial court for appropriate relief. Full stop. In view of the aforesaid submission, the instant bail application is closed and disposed of.
17.
CD also receive. It can go B. It can be the CD also receive. Whether in this case actually we have written a CD. There was the ready PCR has been shown. Actually, CD has to be called. So, scan copy of the CD receive. So, nothing here because subject submitted, but subject submitted of 15 people receive.
Okay, you go there. You go there. Appear.
I'm paying.
No. You go there. What will happen? I mean, it will be unnecessarily stuck here. You go there, approach there. You'll get another forum. It will be better for you. The same order you pass. Same order you pass. But only that charge sheet number. Mr. Borua, give the charge sheet number and date. You go there.
estimating,
$58 days. 60 days mandatory period. What, Mr. Borua?
Minimum 5, next time.
1 second. 25?
One.
It BNS con 9. BNBS, BNSS. You can check. You actually chamber logs more 30 books. You can hunt talking no follow. Yes. What is the statutory period of detention? Arms Act is also there. 25 1A, Arms Act is there, then 310, what, 310? 310 is not 60 days. Shall not be, see, whoever makes a liable to fine, whoever makes.
25 1A is about the criteria though. That's what I remember. Centers are concerned like this. There's a great open society man. One of them, one lady man for the department. That's a man of the interrelation of the other. Yes, then by in man of 100. And especially for those who don't get by the service. The capital word life.
Hmm? Hmm? No, it need not be related. No. He's there. I mean, it's there. You don't need, I mean, you don't get, elite class in every places. A witness needs to be there, witness is there. And I mean, all offenses is come up with 36 saying only, in all the cases, it will not serve. Mhm. You have the CD? Get me the CD. what is his name? This person accused? It is there, Mr. Counsel. LTI is there, LTI. Heard, Mr. No merit. Heard, Mr. So it's FKR Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. RJ Burua, learned APP for the state. This is an application, you write that, then you write. The gist of the case as has been narrated in the FIR dated FIR dated 1/1/2026, lodged by one Joyanta Nara SI in Jamunapur police station on the same date, alleging inter alia that on receipt of a reliable information that a group of 5 people were preparing to commit dacoity on National Highway 36 by 36, the police team proceeded to the s- to the aforesaid spot and intercepted a vehicle from where the police recovered 122 pistol, 22 pistol made in China from the possession of one Salima Khatun. Full stop. The police team apprehended 5 numbers of persons, including the accused applicant, from the vehicle. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is already behind the bars for last 58 days and 58 days, and he has been arrested only on the basis of suspicion, and no pistol or any arms have been recovered from his personal possession. Full stop. Therefore, he submits that the accused applicant should be granted bail at this stage. The case diary in the instant case has been received and the same is perused. Next para, the learned APP, on the other hand, submits that the case relates to attempt to commit a dacoity, and wherefrom the police recovered a live pistol with active bullets, uh, uh, full stop. He further submits that on the during after the arrest, on intimation of the one of the on intimation of the accused persons, another pistol has been recovered by the police. Full stop. In view of the aforesaid materials, he submits that that this is not a fit case wherein the bail should be granted. Full stop. This court has gone through the materials brought before this court by way of the case diary, as well as heard the submissions made by respective counsel appearing for the parties, and is of the considered opinion that at this stage the accused applicant should not be granted bail. Accordingly, the instant bail application is rejected. No, nothing. That 21.5 is 21.5 is I mean 21A, 21. That Arms Act is clear. Extend to life. Extend to life. You see, I mean, if you get something, some material, you file an application. I mean, subsequent application also you can file. If you get some material on that, if you think that you still have something on that, then you can always file an application.
19,
But we have not received this, Qadir. Huh?
There's a case number in here.
But TCR has come. No, I didn't get it. What? Which order? This court's order. It is reflected what? Ah, it should be 2025. These people make mistakes. You're right, you're right. You are Mr. Mr. H. Agarwal, the learned counsel appearing for the accused applicant, submits that the TCR in the instant case is not received due to the fact that in the order dated 12/2/2026 of this court, the case number mentioned was special sessions special case number 2026 instead of sessions special case number 206/2025. Also, in view of then you write registry to call for the TCR from the court of the special POCSO Kamrup Metro Gauhati in connection with session special case number 205/2026. 206 of 2025. See, this order was passed on 12/2/2026. Why you were sleeping for this time? Why didn't you come or like intimated the court master? You have seen the order today only. Then you should immediately check. I mean, sometimes these numbers, I mean, they're typing, they commit some, I mean, there's some typographical mistakes happen. So you should be careful. Always see, I mean, the numbers and all.
Already 5 months behind the bar.
Okay, we are fixing it on 25th. Later TCR come, fixed on 25th. Huh? No, that will not possible. The full board is full.
5 months behind the bar.
POCSO matter, POCSO matter, 5 months behind the bar. Okay. Okay. Yeah, the 25th. Not before that, not possible. The board is full. Otherwise, I mean, court doesn't have any problem in. That hasn't come also. Without that, the matter cannot be heard. Learned APP to get instructions about service of notice on respondent number 2. Okay, pass over time. Passover for time being, you said, na? Day. Okay. On the URMS, on the request of MS Das, let the matter be fixed on the bail application. Fixed on 18 March.
21,
Subsequently, procedure was called for. Now, official dated 25 to 26. No steps received by the registry. They are not taken steps.
None appeared for the accused applicant when the matter was called. He is appearing on. You have not taken steps in this matter. You are appearing in this matter. Item number, you are D. Bourbon. You have not taken steps for service of notice. You have not taken steps for service of notice till now. Why? You'll have to take steps for service of notice, correct? Respondent number 2. Hmm? Hmm? The Dipanjali Bonia is there. Okay, office note, Mr. D. Borman, the learned counsel for the accused applicant is present. Office note dated 25/2/2026 reveals that steps for issuance of notice on respondent number 2 is yet to be taken. The learned counsel is directed to take steps within a period of 3 days of passing of this order. Let the matter be fixed on 24th of March.
23 and 24.
CD has come. NDPS, what is the quantity? We'll have to post it on another date. I mean, the NDPS case without looking the CD difficult. The both matters. Okay. Heard Mr. P. Chaudhary, learned counsel, appearing for the accused applicant. Also heard Mr. K. Parasar. CD not received. Let the matter be fixed on 6th. 5th of March.
Number 52.
Let it be after some time. He hasn't gone through it. Possible. Appearing for whom? Yes. Who is this? Okay. You write, heard Mr. AI. 2nd March should be. 2nd March, too many matters I fix already. Heard Mr. AI within the learned counsel appearing for the accused applicant. Also heard MS Saikia on behalf of SD Borua, the learned counsel appearing for respondent number 2. Respondent number 2. She submits that SD Borua is not keeping well. Therefore, prays for some accommodation. Let the matter be fixed on 9th we are fixing it. She's not keeping well, he's saying. She's traveling to Kohima. Okay. So we'll,
One and the
hmm?
twenty.
We'll fix it on sixth.
Bail hearing item 25.
He's seeking some accommodation. When? Hmm? Okay, on the prayer of the, learned on the prayer of the council appearing to the West Council, for the respective parties, let the matter be fixed on. On 12th.
26.
Pass it off for time being. Okay. We'll just come back in 5 minutes. Hmm? Hmm.
They have asked for updated signals from the high rate of, I don't think next week. We will get the updated.
Mr. P. Bothakov, the learned counsel, I Bothakov, the learned counsel, appearing. Learned Bothakov, the special PP, wildlife, submits that updated CD in the instant case is yet to be received. It raised for some accommodation. Let the matter be listed. On 11th.
Item 28.
Interim orders of past earlier shall continue. Huh? Interim orders of past earlier continue. Okay, raised to call for updated, he write his name and his name, present. Just present, huh? Present. Updated TCR in the case, in the instant case is to be called for by the registry. Let the matter be fixed on 24th March. Then you write interim orders of past earlier and continue to the next date of listing.
P.
Okay. Okay. Heard Mr. P.K. Roy Chaudhary for the accused applicant. Also heard Mr. L. Devi, the learned counsel, appearing on behalf of Mr. R. K. D. Chaudhary, the learned Deputy Solicitor General of India. MS Devi submits that Mr. Chaudhary is out of station and therefore prays for some accommodation. Let the matter be when let the matter be fixed on 18th. Interim order so past tender shall continue till the next date. Next.
51,
Who is the senior? Okay, for time being.
52,
CD not received. Let the matter be listed on 23rd. Say AB application. no? Let the matter be listed on 10th. MSLDB appears for respondent number 2 as legal aid counsel. Let the matter be fixed on 19th. No, let the matter be fixed on 10th of March. Was there any interim order?
P3,
Service report of service of notice on respondent number 2 is awaited. Let the matter be fixed on 10th. 11th. Okay, let the matter be fixed on 11th.
34,
Yes. Mr. A. Mr. Learned Counsel is. No, we'll have to show, we'll have to see the CD in this case. Mr. A. Mr. Learned Counsel for the accused applicant is present. Chakraborty for DRI submits the CD in the instant case is said to be received. Let the matter be fixed on 10th of March. No, not before that. All dates are full. Otherwise, I would have given. It's better to dispose of cases rather than keep keeping it pending. So we give the dates, as soon as possible. That's why I'm saying 10th, not before that.
number 11 for admission.
Yes. Respond number? It was delivered to the respondent number 2 as per the track record, but none is appearing. Matter relates to what?
The harmful. But she that produces this identity of the contents company, this company fifteen that produces surgical goods. Now on the allegation, he lost the fire item returns to 25.
Where is that? Thirteen. One second, one second. You have addressed given the address Delhi. Why not in Guwahati? Why not in Guwahati? They have a factory here. No, they have a factory in Paneri. Paneri Boko. Just let me read the allegations. Where is your design certificate? You have a patent on the design. Where is your patent? Hmm? 47 and 48. This is for what? 47 is for what? This is GST certificate. I'm asking for a patent certificate. Registration of what? The registration of company, how the registration company will do? You are saying that you have a patent design. No. You show me your patent that you have a patent over the design of surgical globes or whatever. You said you have a patent, no? I mean, in your complaint. You'll have to show to the court that you have a patent and you have, I mean, your patent has been violated.
My patent certificate should then if I copy the design from my next company, then patent certificate is not
I'm not talking, I mean, see, your allegation is that like your design has been taken by somebody else and for manufacturing, they are manufacturing similar material, surgical goods. So first of all, you'll have to have the patent on that. Then only nobody can copy that, right? Then your allegation is that somebody has copied it, your design has been copied and they are manufacturing it. So first of all, you'll have to have that certificate. So where is that certificate? I am asking it, is it unreasonable? And you are saying something else. It wouldn't have been given by somebody. Your allegation is that like they are not patented. They have not taken any patent certificate. And once a patent has been given to somebody, then another person applies for the same patent that won't been given, that won't be given because they will do some inquiry before giving. But you yourself saying that like you have a patent. Now you are unable to show me that you have a patent certificate on that design. So your company is in Rajasthan. Hmm. Hmm.
So in that circumstance also the complaint would not for with regard to my son, I was
But let me understand the case first. So FR was filed, then final report I'm talking about. Hmm. Hmm. Understood. Then, uh, hmm. Okay, now you have come forward. You are Mr. Sanjeev Gaur, right? So you have come against that FIR.
The final report had already been submitted by the police.
Hmm.
And the respondent number 2 had submitted protest petition regard to the final report. And after that, the court would have taken cognizance in the method. They allowed the respondent number 2 to proceed. The statements were recorded in the and after that, cognizance was taken against him. Fire also there committed in the state of Assam. If we agree with the offense committed in Rajasthan, because my factory is in Rajasthan.
Your factory is at Rajasthan and respondent's factory is in Paneri. Complaint was filed by you. Complaint was filed by you, right? I'm not understanding what you're saying. It will take some time. We'll fix it some other date. Short date. We'll have to go through this. Let the matter be fixed on 25th of March. Interim order so past earlier, I'll continue. Mr. Borwa, will you also look into this? I mean, there are certain things. We'll see. We'll see. We'll see. I mean, see, you stay in, your company is in Gurgaon, Noida, and somebody from here, from Guwahati has alleged, right, that patents are being violated. Now, a complaint has been filed in Guwahati. Now, you are saying that you stay in Gurgaon. So no, I mean, there is no jurisdiction of Boko Court. That is your case, right? Mm. We'll consider it will take some time. So I mean, today, I mean, it will be difficult. Yeah, the jurisdiction, we are aware of this and we'll have to examine the thing. That's it.
Item 51, supplementary list.
Index. Earlier DBA. Earlier under the DBA, payment was late. The one was after the thereafter the made by the payment.
Yes, Mr. Bormon, you are ready? Hmm.
Report is also to provide a copy of the same. So you can find a reply in both the cases and the question.
Yeah, another matter pending.
Here matter DBA. I have challenged that order pending.
That is pending.
Criminal illegal.
So I mean, both the matters should be taken together then. Huh? And you don't have a copy of that. Somebody else is appearing. Okay, you serve me a copy.
Is the order of the time for order. Subsequent order may be continued. The petition is suffering.
No, now you are saying that like you'll have to file a reply to that. And now order has been passed on consideration of the materials and submissions. Now how it can be suddenly Nico Hard, Mr. DK the Learned Council, DK Nath, the Learned Council, and Mr. D. Varman for the respondent. Mr. Nath submits that, now Mr. Borman submits that there is another matter, another criminal revision that is number 61 of 2016 is pending before this court relating to the same dispute. Full stop. He submits that a copy of the same is not available with him and he would like to file an objection to the aforesaid revision. Full stop. He further submits that since the matter relates to the same issue, both the matters should be tagged together and heard together. Mr. Mr. D. Nath, the Learned Council, doesn't have any objection to that. And he also prayed for the same. Accordingly, let this criminal revision petition be listed along with the other one. Full stop. In the meantime, the Learned Council for the Mr. D. Nath, the Learned Council for the petitioner, shall serve a copy of the aforesaid criminal revision petition to Mr. Borman, the Learned Council for the respondent in the instant case. Let both the matters be listed on 26th of March. Interim orders so passed earlier shall continue.
Standing at 31.
Yes, Mr. Parasar, anything is there? Let him go. I mean, nothing. Heard Mr. M. Khan, the learned counsel appearing for the accused applicant. Also heard Mr. K. Paraswar, learned APP for the state. This is an application you write. Then the gist of allegation in the FIR dated 18/1/2026 that on 1/1/2026, taking advantage of absence of uh, the informant's husband, the accused applicant entered into their house and committed rape on her. It was alleged that at that time her children were sleeping in another room, uh, on another room, and upon hearing hue and cry, neighboring people came and the accused fled away. A coordinate bench of this court, wide order at 6/2/2026, has granted interim pre-arrest bail to the accused applicant in the instant case. And in terms of the aforesaid order, the accused applicant has already appeared before the investigating officer and got his such statements recorded. Taking into account the entire facts of the case, as well as submission made by the learned counsel appearing for the parties, this court is of the considered opinion that the interim pre-arrest bail so granted earlier should be confirmed at this stage, full stop. Accordingly, the interim pre-arrest order dated 6/2/2026 is made absolute in the same terms and conditions and as mentioned in the interim order, full stop. Accordingly, the instant ABA application is disposed of. CD to be returned.
Orders item 36.
Some phrase steps we have taken. Hmm. Hmm. On 7th. So today, I mean, so we heard Mr. Talukdar, the learned counsel of the council appearing to the accused applicant, also heard Mr. K. Paraswar. Then you write with office note dated 6/2/2026 reveals that notice has been sent to respondent number 2 to the office of learned PP. However, the report of service of notice on respondent number 2 is yet to be received. Let the matter be listed on when do you want? Yeah, on 26th of March.
Item 57.
Okay. Service on respondent number 2 is awaited. Let the matter be listed on 26th of March.
P8.
Hmm? Two 2013.
They have filed.
Hmm? The I is not here. What? You have filed substitution application when? When did you file it? Till now what you were doing? Hmm? So, so you don't have any obligation to your client? Hmm? No, no, I'm asking you something. No, 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 I am asking, I mean, why you have been waiting for till from 2019 till date? Today is 2026. No, don't show me all these things. I'm asking like last 7 years, what you have been doing after filing of this application? LCR not received? Mr. AI Hazarika was appearing in this matter. Who is appearing? Huh? You are for the respondent. You have seen those cases, citations, you have given him given a copy. So you raised an objection saying that in criminal petition, there is no the provision of substitution. That is your objection, right? Now he is submitting these two cases. These two cases he is submitting from the Supreme Court. Supreme Court wherein Supreme Court has stated that in the proceeding under 302 CRPC, the permission can be granted. So what is your submission on that? No, no, main case, forget about main case. I mean, now that this is for substitution, you want to go through these cases? You go through these cases and we'll fix it another date, then you submit your thing. Heard, you give her a copy also. Give her copies. Heard, Mr. Okay, Hangal, the learned counsel this in IA, for the appellant, for the applicant. Also on Mrs. MS Yunanda for the respondent. Full stop. On the prayer of on the joint prayer of the council, they'll let the matter be listed on on 25th March. Mr. MS Nanda, you be prepared on this.
39.
একদম চাব লাগিব মই হা কোনটো এনেই মই চাব লাগিব কোনটো None appeared for the petitioner when the matter was called for. Let the matter be listed on 24th of
for five. Same as this. Here's what, 4 and 5 are the brothers.
Okay, nobody is there. I mean, you write, Mr. A. Hangal, A.K. Hangal appeared for the petitioner, whereas none appeared for the respondent, private respondents. Private respondents, let the matter be fixed on. Let the matter be fixed on 25th for admission. Service is completed. But it says now 25 to neither the AD card nor service. Hmm? Hmm.
Same as this.
Five appearing, somebody is appearing for 5. Kalna for file for 5. No, it may be same address, but let them come and say, how do you know? Yes, we do. We can't say that. Maybe same address. There are two persons, different persons. It is come in the orders of. No, let it be listed in orders, and we'll see on 25th. Let the matter be listed in orders. Let him appear.
Item 40.
You are appearing as? Huh? This is 50, 40. 53 is connected with 40. And you are appearing for in which matter? In 53. Hmm. Mr. Nawaz is there. So let him come. It has to be heard together. What are the relations? Already you have undergone. So we'll fix it up in the next week sometime. Other criminal appeal means that 53. Then where is that? Where is the pending? We don't know. A 53, if I'll you have checked. Heard Mr. S. Datta, the learned counsel, appearing for the appellant. Also heard Mr. K.K. Parasar, the learned APB for the state. Mr. S. Nawaz. The 40th you are not appearing, only 53. 53 you are, no? Yeah, item number 53 you write, as doctor and Parasat. Then you write, if connected appeal, that is criminal appeal in bracket J 1072024. Uh, 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 in connected appeal so and so, Mr. S. Nawaz has been appointed as a amicus curiae, but he is not present today in the court. In view of the aforesaid, both the matters, criminal appeal jail 107 and criminal appeal number 398 of 22. And what about this? Okay, the IA has been filed by you. Only the IA. Okay. Criminal appeal number, what is the number? 25, 24, to be listed together along with the IA criminal 102/2026 filed in criminal appeal jail in jail 107 of 2024. Let the matters be listed on 24th.
41.
Service on respondent number 2 is awaited. Let the matter be listed on 17th. 17th, we're giving a short date. You are Mr. I'll just write his name.
44.
Because none appeared for the petitioner, none appeared for the applicant when the matter was called for. However, your name? D. Chakraborty appeared for? Respond. Huh? Respondent number 1. There are 2 respondents. You are appearing for? Who? Minal Kumar Boro is appearing for whom? This is an appeal filed by union, right? So you write none appeared for DRI, the appellant. Now this is an IA they have filed. No? There is an appeal also. What? Appeal has been numbered or not? Appeal is not numbered, is it? Appeal to number isn't there? No. IA is for what? Okay, in this IA you write 636 IA you write none appeared for the DRI, the applicant when the matter was called for. Though MS Chakraborty P. Chakraborty appeared for respondent number 1 and 2. She submits that she has filed a wakalat number only today. Therefore, 6 for some accommodation. Let the matter be listed on 26th of March.
55.
None appeared for the petition. None appeared for the applicant when the matter was called for. Let the matter be fixed on 25th March.
46.
Who is for the other side? So he's in custody. How come he is in custody if he's, I mean, you're coming for a cancellation of bail? Hmm? Heard Mr. P. Katoki, the learned counsel, appearing for the accused applicant, appearing for the state, right? Appearing for the state. He submits that service on respondent could not be completed as the respondent is inside the jail. He submits that he should be allowed to service the notice of the instant matter in the jail. And the prayer is allowed. The learned counsel for the state will serve the notice of this case to the respondent inside the jail, and thereafter he'll file an affidavit. Thereafter, he filed an affidavit to that effect before this court also. Let the matter be listed on when? Okay, 18th, will you please say 18th? No? Yes, yes, yes. Yes, yes.
That's it. That's it. 19. It was reserved for listening.
আছে না?
Announcement of judgment, item number 57.
On reliance of the aforesaid two cases decided by the Honorable Supreme Court, this court is of the considered opinion that dishonest intention and mens rea prima facie cannot be made out against the accused applicant from the materials brought before this court. To sustain a charge under section 318 and section 316 of BNS 2023, there must be substantive evidence of fraudulent or dishonest intention at the very inception of the contract or transaction. Mere allegation of such intention will not hold legal force. Mere failure to discharge contractual obligation, that is failure in payment in time, by itself will not constitute cheating. Court has to find reliable material to that effect. Similarly, a mere breach of a promise, agreement or contract does not ipso facto constitute the offense of criminal breach of trust contained in section 316 BNS without there being a clear case of entrustment in true sense. Having come to the aforesaid findings, this court does not find it necessary to discuss the case laws cited by the learned counsel appearing for the informant as well as other case laws cited by the counsel for the accused applicant in support of their submissions. This court has also given consideration to the fact that accused applicant has been behind the bars for more than 52 days. And during his stay in the judicial custody, no interrogation has been made by the investigating authority in the process of investigation. Whatever interrogation has been made, admittedly, that was made during the initial police custody. It is also seen that recording of statements of complainants are not yet completed, and statements of only 3 complainants have been recorded till date. This shows the lethargic investigation that is being conducted in the case. Therefore, taking into account the length of detention of the accused applicant as well as the progress of investigation in the instant case, and having prima facie come to a finding that dispute in the instant case is primarily of civil nature, having remedies other than instituting criminal cases against the accused applicant, this court is of the considered opinion that further custodial detention of the accused applicant is not necessary, and therefore directed the accused applicant to be released on bail. Bail granted.